Thank you, Alan. Thank you, Suzanne. Thank you, Alistair. A great session there. And as Alan said, leads us into the next session with Anne. So over to you, Anne, who's Vice President of the IIC as well. Thank you, Anne.
Thank you, Lynn, and thank you, Alan, for the really, as you said, fascinating discussion between key sponsors of legislation on privacy at the federal and state levels. Thank you to the IIC for organizing that. We don't often hear such an interesting discussion between such key players in the U.S. to be. We have now, I think, an international panel, or a panel with an international focus. So I think the final discussion that Alan led is very useful now for some of the topics that we'll discuss on this panel. In typical IIC fashion, we have a very diverse set of perspectives: consumers, U.S. government, a foreign regulator, meaning foreign from a U.S. perspective, but from Mexico, which is going to be very interesting, a data protection regulator, and also a key industry player. Before I hand it over to the panel to really share their views and then have hopefully as interesting a dialogue as we just witnessed, I wanted to just say a few words about some of the key topics that I think are on my mind. I have spent 20 years in Europe working on GDPR and pre-GDPR compliance with European and UK data protection laws, and now having moved back to the United States just prior to the COVID situation, it's been fascinating working with Alan and our global team on CCPA and now the new state laws that are coming online. I think, though, just stepping back, from our perspective, clients, as Alistair, I think, rightly put it, clients aren't sitting there going, how can I violate these laws? Clients want to comply with laws, and it's a Herculean task for them to do this. I think several top issues that are affecting their ability to really understand which way the wind is moving and how they really should comply, really focus on 4 issues. Interoperability. We heard a lot about interoperability at the federal and state levels within the United States, but obviously interoperability at the global level is equally important and equally problematic. The kind of flip side or antithesis of interoperability is data localization, which is in some countries becoming the new normal, and in some countries it's black and white, and in other countries it's a sort of a moving scale. But that issue is also a key issue that companies are trying to cope with and understand how that's going to affect their business case and their ability to serve customers globally or even locally. Another key set of issues, I think really one of the most fundamental aspects of all of this, is the focus on the minutia, and I don't mean to diminish the importance of legislation, but the minutia of legislation versus really the focus on customer trust, and whether we are really at a tipping point right now in terms of customer trust. When you look at the fact that we are being surveilled, not only in the advertising sector, but from a political standpoint, in the workplace, your insurance company, and children. So there are so many issues that are starting to weigh on consumers. How do businesses ensure that they maintain trust? And finally, I think a key issue from our clients' perspective is the interplay between where we are heading with competition and antitrust policy vis-a-vis the major platforms, the major tech companies, innovation, AI, machine learning, and all of that, also in consideration of competition with China, competition with Russia, and various other players in the market, the EU as well, and privacy. How do those things interlink? So those are huge topics. I'm sure we won't be able to cover all of them in the time that we have, but I think these are all issues that our clients and the world are trying to grapple with in this super complex area. So without further ado, let me turn over the microphone to Maureen Mahoney, who is a senior policy analyst at Consumer Reports, to give us the consumer perspective. Maureen?
Thank you so much, and thank you for the opportunity to speak today. My name is Maureen Mahoney. I'm a senior policy analyst at Consumer Reports on our privacy and technology advocacy team. And just by way of introduction, many people are familiar with our magazine and our testing at Consumer Reports, but we also have an advocacy wing where we advocate for strong consumer protections in areas of safety and financial fairness and privacy technology, and that's where I work. And much of my work is focused on the state privacy legislation that's emerged in California and increasingly in states across the United States. So I'll be directing my initial comments to that issue, especially as we're following up on the conversation between the Congresswoman and Mr. McTaggart. So we think it's absolutely essential that consumers have strong data privacy foundations. I think still a lot of consumers in the United States would assume that there's a federal privacy law that protects the privacy and security of their personal information, but that's not the case. We appreciate that momentum for this legislation has moved to the states in recent years. California, as we learned more about in the last panel, Consumer Reports supported Proposition 24. We supported certain versions of the Washington Privacy Act in Washington State. They're a bit closer to CCPA. But regardless of the jurisdiction, we want to make sure that consumers are benefiting from these laws and that the push for ease of compliance doesn't undercut consumer protections. And we feel strongly that privacy legislation should protect consumer privacy by default. We think that consumers should be able to go online and use apps without having to worry about opting in or opting out. They would just know that their privacy is protected. So we're supportive of a strong data minimization standard that limits data collection and sharing to what's reasonably necessary to provide the requested product or service. So that's a little bit tighter than CPRA or GDPR, but it's important to us, especially because a lot of the emerging state privacy legislation we're seeing is based on an opt-out of sale. We at Consumer Reports have tested this. We've had consumers submit opt-out requests under the CCPA to various data brokers and found that it was really difficult to opt out about 14% of the time. And it can be difficult for consumers to process even one opt-out request, much less at hundreds, if not thousands of different companies. So in the absence of strong data minimization, at the very least, we think consumers should have tools to make it easier to exercise their preferences, like a global opt-out, which is required by CCPA regulations and is added to the CPRA is added to the statute by CPRA in our view. Authorized agents, which are third parties that can submit requests on consumers' behalf, can also help make these more workable. We think protections over cross-context targeted advertising are key, establishing that through strong definitions. We also think that it's important that consumers should be able to exercise their preferences without being charged a different fee or different than others, because we think privacy is a right that everyone should enjoy, not just those who can afford it. I know there are concerns about how privacy will interact with the ad-supported web, but we don't think it has to be an all or nothing proposition. There are companies that have been profitable without extensive tracking practices. And then finally, strong enforcement is essential to ensure that companies can comply. So that's where we've been putting a lot of our energies lately, and looking forward to hearing from the rest of the panel.
Thank you, Maureen. We'll move on now to Sam Scofield, who's policy advisor at the Office of Digital Services Industries with the International Trade Administration of the U.S. Department of Commerce. Sam?
Great. Yeah, thank you, Anne. And good afternoon, everybody. And thank you to the IIC for inviting me to speak here today and participate on this impressive panel. So As Ann mentioned, my name is Sam Scofield. I'm a policy advisor in the Office of Digital Services Industries at the U.S. Department of Commerce's International Trade Administration. And for just a little bit of context, my geographic portfolio primarily focuses on data policies in Central and South America, as well as supporting my office's engagement in the Apec Digital Economy Steering Group. I also cover artificial intelligence technologies and associated privacy issues around data processing and international transfers related to AI development. So I just have some brief remarks, and then I look forward to our panel discussion. So from the government's perspective, through technologies like 5G, the Internet of Things, robotics, and AI, we're experiencing a new wave of data-driven innovation, and that has the potential to improve living standards for our citizens, and also address critical challenges related to public health, safety, and the environment. And the ability for data to flow freely across borders is key to riding this wave of data-driven innovation. According to recent estimates, there's about 4 billion internet users across the planet, and every day those users generate about 2.5 quintillion bytes of data, and that figure is expected to increase tenfold in just the next 5 years. And so cross-border data flows have become critical to commerce and trade. According to a 2018 report from the Brookings Institution, cross-border data flows currently drive 22% of global economic output, and that number is going to increase to about $11 trillion in contributions to global GDP by just 2025. So these data flows are vital, and they're important to all industries, even traditional industries such as automobile manufacturers, banks, airlines, hospitals. And individuals, startups, and small businesses also now seek to leverage cross-border data flows to access global markets and global value chains at an unprecedented rate. And governments, we need data flows for trade and commercial relationships, for financial market stability, public health, criminal investigations, and national security. At the same time, because the international flow of data so often involves personally identifiable information, we need to recognize that privacy and data protection are essential, and not simply for organizations to achieve legal certainty, but also for businesses to build consumer trust. Because it is right that individuals know and understand what happens to their personal data. As Anne alluded to briefly, to address this challenge, we are seeing a growing trend towards stronger data governance laws at a national level in both liberal democracies and authoritarian states, often in the form of data localization laws, and that's leading to a more fragmented regulatory landscape. While the US government acknowledges that there are legitimate public policy objectives for protecting data privacy and security, requirements to keep data in country generally hurts our businesses and our citizens. For example, when global banks do not have access to their data from around the world, they're less able to spot malicious trends and fraudulent activity. That leaves local banks and domestic financial systems vulnerable to very real and very expensive threats. Additionally, data localization not only limits the ability of companies to do business overseas and imposes significant operational costs, but it ultimately may not provide meaningful data protection or privacy. As a result, the United States has to propose alternatives to these restrictive approaches that enable the free flow of data as part of cross-border commerce. And further, the global economy urgently needs an international framework that is interoperable and scalable. So what is the United States doing on this front to advance that objective? The United States supports interoperable approaches to privacy regulations, which provide effective and enforceable data privacy protections and are flexible to accommodate different legal regimes in different countries. And a key aspect of that work that we're doing within my office and the broader US government is promotion and expansion of the Apec cross-border privacy rules system. This represents a key part of the United States strategy to establish interoperable frameworks that facilitate cross-border data flows while ensuring that the protections placed on that data travel across jurisdictions. So the Apec CBPR system is a government-recognized data privacy certification system that companies can use to certify their global operations to internationally recognized data privacy standards. Currently, 9 Apec member economies participate in the CBPR system: the United States, Canada, Mexico, Japan, Korea, Singapore, Australia, Chinese Taipei, and the Philippines. And collectively, that participation supports about 4.4 trillion in trade and investment between these 9 economies. The Apec CBPR system also provides a flexible and legally enforceable system of mutually recognized data privacy best practices and standards across economies that have different regulatory regimes. And the Apec CVPR system does not replace domestic laws. This is very important. The system recognizes instead that differences exist among economies' laws, but it establishes baseline protections for what all of those members have in common within their laws in terms of data protection, and then requires businesses to comply with any additional and specific requirements in each economy. And lastly, we see the Apec CVPR system as also serving as a vital mechanism and framework to facilitate data transfers that are going to continue to grow with the rollout of emerging technologies like artificial intelligence and 5G, as well as in the development of smart cities. And so I would just say that as far as the kind of next steps with this priority for the United States, we are exploring with the other members of the CVPR system, making the CVPR system a global certification and expanding its availability to participants outside of APEC, including in Latin America and the Middle East. And in just the past 12 to 18 months, the United States has engaged with trading partners outside of APEC to educate them on this certification system and explore where there may be opportunities for interoperability between their laws and ours, potentially by recognizing the CVPR system. So just in conclusion, we generally believe that the best path forward to ensure data protection does not disrupt the global data flows is one built on cooperation, and governments should work together to ensure that data protection is consistent and enforceable across jurisdictions. So I'll turn it over to the other panelists, and I look forward to our discussion.
Thank you, Sam. Next up, and moving away from sort of the focus from the US perspective, we're going to Mexico. And Vitelio Ruiz Bernal is the General Director of Investigation and Verification of the private sector, which is a very scary title, I have to say, if you're a lawyer, of the National Institute of Transparency, Access to Information and Protection of Personal Data, also known as the INAI. So over to you, Vitelio.
Thanks, Anne, and thanks, ICC, for the invitation. Just to let you know, yes, kind of scary, but not so much. We try to help everybody. But on my daily basis capacity, I'm in charge, obviously, to verify and make sure that the enforcement of the Mexican law is complied and that all the companies actually comply with the Mexican law. We obviously have right now two laws, one law that applies just for the private sector and a second law that applies to all the public entities in Mexico. So from this perspective and standpoint, what has been relevant ultimately here in Mexico, at least for the private sector standpoint, is obviously the interoperability with other jurisdictions and other countries. One of our main concerns right now is how we're going to apply the dispositions that have been recently adopted in the new treaty, the new commercial treaty that we signed with the United States and Canada. And obviously one of these approaches is the CVPRs of APEC. So Mexico right now, the only thing that is missing is to actually have a certification authority that actually enables Mexican companies to get this certification. But pretty much our laws states and the principles of the APEC are aligned, so that we know by a fact that we would be easily implementing this because we have almost 10 years or so of a private sector privacy law. And pretty much every company, at least all the medium and big companies, have stated and start implementing best practices so that they can actually operate in a cross-regional and cross-jurisdictions point of view. We are, obviously, it's important to mention that Mexico has and hybrid scheme. So we adopt the minimum best practices of the European model and the GDPR in some sense, but also the auto-regulation of the American model. So we have both things. So we have like a minimal ground of what should be complied in terms of privacy and protection of personal data, but there's also room and space that the companies actually adopt better practices in their sector or within their industry so that they can achieve a better level and to create trust between consumers and their clients and us. So from our experience, it's quite important right now just to agree between countries what actually personal data protection means, what are the principles of data protection, how they may be seen, and how we can comply, all of us, and agree that these are the minimum standards or the minimum that we should be achieving. Because obviously, as Sam was telling us, we are interested in having data flows because it's quite important right now. And if you want to be on the 21st century economy, you just should be having data flows, but these data flows should be protected, and that we should be complying with the laws on every country. That it's quite difficult and it's quite a challenge. Any data protection officer on any company could tell you this, on many multinational, is just complicated, but it's achievable. And I think that that should be our main scope right now, how we can make that all the laws between all the countries and all the principles are complied in a certain way, that we all know that the data is treated in certain same ways with a certain minimum standard level of protection, so that we can actually do business but don't lose or don't affect the rights of people and consumers. From that point of view, what we think is something achievable. Mexico has been working on that capacity, and also as chair of the Global Privacy Assembly, we are trying to work obviously with all the regional networks right now to discover what they are working and how can we align these kind of concepts. So it's going to be part of the focus of Mexico on the next couple of years, and obviously for the GPA and all the international forums that we actually belong, just to push something that is understandable for everybody and that we can agree. So build on commonalities instead of differences, because it's quite difficult to just ask any country to change their jurisdiction and their laws just because they have to comply. We know that we have to make some adequations to our laws, and obviously many countries would also have to do it, but from the point of view of what we can start with and what we can achieve on commonalities, and then go deeper on that so that we can achieve like an international gold standard of what data protection should look like. That's pretty much important for us right now, because obviously we have complicated traffic and commerce, because we make traffic with you guys in the United States, and you're our #1 business partner, but we have also significant commerce with Asia and Europe. So for us, make sense of something that all the companies can achieve is really important right now. That would be it. Thanks. I would leave for the panelists.
Thank you, Vitelio. And last, but certainly not least, we'll hear from one of the leading global tech companies, and I would say one of the more thoughtful ones operating in this space. We are delighted to have Chris Calabrese of Microsoft, Senior Director for Privacy Policy. Chris?
Yeah, thanks so much for having me. This has already been really interesting, and I hope to pick up on a bunch of the themes that I've already heard here. So, I mean, I think I would just begin with the fact that Microsoft has been advocating for strong interoperable privacy laws for years. And there's a reason for that, right? I mean, we just think it's vital for building trust and for supporting the adoption of new technologies, which is, as a tech company, what we're all about. And I mean, I think the numbers back this up. Surveys of America, just in the United States, surveys of Americans found that 90% of people surveyed said they were concerned about the sharing of their information. 7 in 10 said they didn't think the government was doing enough to protect their information. So I think people are sensing this, and I think it's certainly, if you look at their behaviors, and we could talk a little bit about how data is being used, but we see consumers' concerns playing out in a number of ways when it comes to their personal information. But let me just start by saying, well, you know, what does it mean? What does a strong interoperable law mean? From Microsoft's perspective, it's really 4 core things. And there's obviously, and as you've alluded to, a lot more detail in these laws, but we would start with 4 pillars. And the first is transparency. You have to really know what the companies are up to in order to understand what you might want to do with your personal information and have confidence it's being used properly. We want to empower individuals. We want to give them the individual rights that they deserve. And when the GDPR gave access correction and deletion rights to people in Europe, we were the first company to expand those globally. We said everybody deserves those rights. And the third is something we believe in very strongly, and that's corporate responsibility. At the end of the day, the companies that are collecting this information have the best visibility into what they're going to do with it, how it's going to be used. And so it's on us to use it appropriately. It's on us to restrict collection to what's appropriate. Third-party use should be in the context that the consumer, it was collected in and that benefit the consumer. So, this is really important that it fall on us. And then the last thing is strong enforcement. I mean, we have to be held accountable. Consumers, having rights aren't really, I don't want to say they aren't valuable. It's critical that in order for a consumer to have rights, they must also have remedies so they can do something if those rights are abrogated in some way. And, the reason we do this is because we believe in building consumer trust. And part of that is really because we believe in the 21st century, data and the flow of data, as has been alluded to by others, is really foundational to our economy. It's another kind of infrastructure. It's like electricity, it's like roads. You need to have this infrastructure and this data sharing in order to maximize economic growth. And so, I think that, and also benefit society. And I think we saw some interesting examples of this as we've gone through the COVID crisis. On one side, we've seen the sharing of information be incredibly valuable in, for example, speedily approving vaccines. In the UK, we were able to see the UK pull together a tremendous amount of health information in a secure setting, use that setting as a way to test vaccine efficacy. Incredibly valuable use of data, and one that I think people support. At the same time, we saw contact tracing and the idea of putting contact tracing apps on people's phones as something that really didn't take off, certainly not in the United States and in many parts of the world. And I think part of that was because of a fundamental mistrust of where that information was going to go. It was very sensitive. It is very sensitive. It's people's location information. And I thought both Apple and Google did a good job of limiting and restricting how that information could be used so it wouldn't be misused. But the reality is, without legal underpinnings to defend that, it becomes harder to adopt these kind of new innovative solutions. And so, big picture, I guess I would say, and I'm really looking forward to kind of getting into this with the panel, that there's some things that we should be thinking about beyond just legislation. And so I'll sort of leave with these handful of ideas. One is, I think there's more that we can do with privacy enhancing technologies. I think we're on the cusp of really an expansion in everything from homomorphic encryption to differential privacy that can let us do more with data without as many privacy harms. I think we really do need to begin to build controls over personal information and expand them, elaborate on them, let consumers see value from those controls and what they can do with it when they can access their own information. I think the third thing is that we talk a lot about tech, right? And rightly so. We are collecting a lot of personal information. But at this point, every company in the country is a data company and is collecting a tremendous amount of information. So you have to make sure our protections recognize that and we expand them to include, everybody in the economy. And then I think, I've already talked a little bit about redress. I'll just underscore it again. Redress is really important. No matter what the harms are, consumers have to have the ability to redress them. And then the fifth thing I'll say is that I think we're going to get into a discussion of national sovereignty and data localization. I think it is important to say free flow of data is important, but so is countries having the ability to control their own data and their own digital infrastructure, the rules in their countries. And I think there's a way that we can have both of that. We can have both data flows and controls for countries. And then the last thing I'll say is, and this is something that Congresswoman Del Bene said, and I think is very right, is this is an iterative process. We really need to accept that, we're not just going to pass a law and that's going to be the end of it. we really need to accept that we're going to see changes. We saw a huge step forward with GDPR, but we're continuing to see nations iterating on GDPR and coming up with more and coming up with refinements to that law. So I think we need to be in an iterative mindset when we think about this, both to protect consumers, but also to maximize the benefit of data. So thank you very much for having me.
Thank you, Chris. I think it would be great if we could stay on this interoperability point that I think everybody has addressed in one way or another. And I'm thinking back to the Delbany-McTaggart dialogue about preemption and sort of lowest common denominator versus allowing for there to be individual improvements or enhancements depending on the sort of national culture. And I also think that, privacy, when you think about the broader concept of privacy, not just with regard to data, which is a subset of the larger issue, it's obviously very culturally rooted. What's private in one country may not be considered part of the penumbra of privacy in another. And I guess we're trying to sort that out in the United States in some pretty huge areas beyond data. So I guess I'm just trying to get my head around how you can have the Apec CVRs, which at least from my perspective are not as stringent as the framework that the Europeans are trying to put in place. You have countries like Mexico that are trying to grapple with both because they have a foot in both camps. Japan would be kind of in the same boat. Many other countries are as well. And then you've got consumers. We talk about redress. I mean, with these vast sort of international frameworks, how do we get enforcement that's effective to actually make sure that if these frameworks are in effect, that they are actually biting? So that's a huge topic. And Chris, you covered a lot of territory there, but maybe Sam, Maureen, and Vitelio, you could sort of take that on, and then we can give Chris a last word on the discussion.
Well, I would just say briefly that, in general, it is a challenge to try and make these various legal regimes and frameworks interoperable with one another. However, I think we're generally better off having multiple kind of multilateral frameworks than having, 190 different individual data protection laws that don't have bridging mechanisms between them. Also, as you pointed out, yes, generally the GDPR as an EU-wide regulation is considered more stringent than the rules within the Apec CVPR system. However, a couple things: the Apec CVPR system is more of a baseline set of commonalities across the economy. So a company that's certified, with the CVPR across the 9 participating economies, if one economy has a mandatory reporting law on cyber breaches, you still have to comply with that, even though that's not dictated in the program requirements of the CVPR. But it's more of sort of a trade facilitation mechanism that streamlines your ability to move data between those jurisdictions without the fear that you're constantly going to be, in breach of individual laws. And additionally, as you mentioned, there are examples of economies that have their feet in both camps. So, Japan has an adequacy decision from the EU. It also participates in the CVPR system. Canada does as well, although I believe Canada's adequacy is limited to certain sectors. But then Korea is in the final stages of getting their adequacy decision as well. So we don't view the GDPR and the CVPR system as mutually exclusive. It's just more that the United States needs to be able to facilitate these bridging mechanisms between its own trading partners. And so the CVPR is a flexible system that allows countries to implement it in their own ways. They can establish their own independent certification bodies, being from the private sector or the public sector, and they can still have slightly different laws. But it's more of a statement that we agree on all these common principles. Our enforcement agencies are going to cooperate to ensure that those obligations that companies have being certified are legally enforceable. And it's also, it is iterative. I mean, it has developed. Some of the program requirements have changed over time, and they probably will in the future. So it's more just that we see the CBPR system as flexible, and it's not incongruous with the GDPR. It has some differences, but there's more commonalities than differences, I think.
Vitelio, how is Mexico juggling these two frameworks?
Well, it's quite interesting because recently Mexico is now part of the 108 Convention of the Council of Europe. So we have been pushing up to get our standards at the same level. One of our main issues that we were having were obviously the public sector law. So since we have it, we are pretty much compliance with GDPR right now. And also we have started the process for the adequacy decision with the EU. So it's interesting how it's going to be detailed, because we're kind of aware that we may comply and we think that we're complying, but also we think that our private sector law that is almost 10 years now has the need for getting some updates so that we can comply evenly with that. But on the other side, as Sam is telling us, we have Apec, and we can easily comply with it. The difficulty that we have been finding with that is actually to get the certification entity. That is nothing of special concern about it. It's just a lack of will of our legislators just to say, okay, this is going to be the entity and this is how we're going to do it. So pretty much what we see is that we have a multiple states of what we should be complying, but what we have been observing is that, at least from the point of view of our law, as soon as we can certificate or we can know that there's a certain level of protection or an adequate level of protection, even which standard it doesn't mean, if we are on the CBPR or an Apec, or even if we are complying with the EU and the GDPR, it's flexible for us. So what we can actually see is to make an evaluation of each, make an assessment of each of the models with the Mexico is part. And as soon as we comply with the minimums on Mexico, we can comply easily with GDPR. That will be, obviously, we'll be needing to add some things, but not so much. And we can also comply with Apec because our laws already have those principles reflected. So it's kind of interesting how it's going to look with other countries that are starting with that. And on that sense, what Latin America is thinking of, because we know, for example, that Colombia is working a lot on how to make these laws, their laws interoperable with Mexican laws, for instance, or how we can cooperate for enforcement. So it's interesting how things are moving right now, because all the regulators are starting to be aware that there's a minimum ground that should be achieved. But we are trying to decipher what this minimum ground should be looking like. So these frameworks become really essential part of our day-to-day work and our cooperation, obviously, so that even if we have jurisdiction matters, that it's something that it's quite on discussion right now in Mexico, because our law doesn't state that we have powers outside our jurisdiction for enforcement, but our this second regulation of our law actually states that we can, even if the data is collected from Mexican citizens by any device, even if it's not in Mexico, we can actually have enforcement. But it's kind of tricky on constitutional basis. So we are trying to see how this looks, but we think that we can achieve cross-jurisdiction enforceability if we make cooperations with our agencies. And how this looks like and how we can achieve this, it's going to be really interesting in just getting everybody aligned and acknowledging that these are the minimum principles that we should be achieving on data protection and privacy. So it's kind of tricky right now because we have to comply with multiple things, but our law can give us the flexibility to do it. But let's see how this develops. I think that it's going to be, I think, of the next couple of years, and we're going to start seeing what has already happened on the EU with the countries that are members, but in other regions and other countries. It's not like we haven't done it with the FTC. We have collaborated in some number of cases that are not so much or not as much as we wanted, but we have some sort of cooperations on other years. And it's something that I think is going to be more important for the next coming years as we saw more data flows and many companies operated in multiple countries and multiple jurisdictions.
Thanks, Vitelio. Maureen, from a consumer perspective, I guess, when I was living in Europe, I realized, that all roads lead to Rome, Rome being the United States, because most of the big tech companies are based in the US. So you always have a different perspective when you're not sort of sitting in the United States. And from a Consumer Reports perspective, I know that that is your main focus, but many Americans' data is being exported, for storage or processing, in countries as diverse as India, Malaysia, Singapore, et cetera. Some have very good protections in place for data privacy, regardless of the origin of the data, and some don't. From a consumer perspective, how do you view these sort of bewildering mega frameworks, and what sorts of protections do you think consumers are looking for in that regard?
Sure. So, our priority is strong privacy protections for consumers. And from a consumer protection standpoint, I would like to see the privacy conversation move beyond opt-in and opt-out towards strong data minimization frameworks. And that's for a few reasons. First, empowering consumers is important, but if that means that consumers have to read kind of incomprehensible privacy policies to opt in or opt out, I don't think that's going to work. If you cut down on unnecessary data processing, then you would eliminate a lot of the problems we're seeing with respect to inappropriate data sharing, data breaches, surveillance. And then third, I think that standard could provide a lot of flexibility for businesses, so that you don't need to have a lot of consent dialogues, for necessary processing. Businesses can get the data that they need, and it would be a flexible standard, for other countries as well, because as you're saying, privacy is, culturally constructed to a certain extent. So I think that should form, the heart of privacy protections. Other things we're looking for, which are established in many international laws, are a broad definition of personal information, access, deletion, portability, and correction rights, and of course, data security requirements. And, I think harmonization is important, but obviously we'd like to see harmonization with the highest possible privacy standards for consumers. I do think it makes sense for both states in the United States and states around the world to have flexibility to evolve, to respond to changing data practices. What we're actually seeing in the United States is something of a race to the bottom in terms of legal requirements, trying to undercut California, but I feel confident that companies can comply with a higher standard. What we've actually seen when comparing what it's like for consumers to exercise their preferences in Europe versus California, a lot of companies are implementing some of these same interfaces and dialogues, and it is consistent from what we've seen. So those are the points I'd like to make.
Thanks, Maureen. Chris, obviously feel free to address any of the points that have been made, but I'm curious in terms of the redress point that you made. Obviously, Max Schrems has shown us one way of, protecting consumer rights through litigation on behalf of consumers through his group NOYB. I'm not sure that's probably what you have in mind in terms of consumer redress. What's a consumer to do if they feel that if a company is part of one of these frameworks, how does that work? What are the practical implications for consumers?
It's a great question. So one thing I'll just say before, and I promise I will actually answer that question, but I just want to know, as I was listening to everybody, how much hard work is going into making harmonizing data protections around the world, that how many smart people are thinking about that. And I think that just underscores the importance of this. And I also think that GDPR is only 3 years in the rearview mirror. It's not like a law that was passed decades ago, right? And we've seen tremendous uptake around the world. The Brazilian law looks a lot like GDPR. The new Chinese law looks a lot like GDPR. I suspect the Indian law will bear strong resemblance in a lot of ways. A number of the state laws, Virginia probably most notably, look a lot like GDPR. So I think that we're seeing a strong move towards harmonization, and it's not going to be perfect harmonization, but that's, I think, important and encouraging trend. When it comes to redress, so first of all, I think that we do need strong enforcement from our enforcers, whether that's more money for the FTC in the United States, whether it's the ability to have a first-time penalty authority. I mean, these are important regulatory steps that allow the FTC to do their job. And then when it comes to sort of redress at the individual level, certainly it seems reasonable that companies should have a mechanism, for example, to cure harms by going directly to the company and having to have having that company address their concerns, and if they haven't, for example, created an access right that's workable, that the company have a chance to fix that. But then if they don't, the consumer should be able to take that up the food chain. That should not be the end of the conversation, bring it to the regulator. And ultimately, I think we would say that, injunctive relief is something that we should think about in this country, think about whether the court should be able to enjoin particular practices, and if a company is not, for example, giving you the ability to delete your information, that ultimately you should be able to go to a court and get that deleted. And I think that when it comes to individual damages, certainly there are harms that come to consumers, and I think it's important that we think about how we can make sure that those consumers are made whole from those harms. I think the other piece I'd underscore here is the one that we've talked a little bit about, but I think is important to really drive home. And that's that the absence of US privacy law, a US federal privacy law, is really important, obviously, because of the harm to consumers, or the lack of ability to redress harms for consumers. It's really important because of the trust element, but it's also important if you're an American policymaker, because it deprives the US of the ability to lead on this issue. If you don't have your own view of what data protection should look like, it's hard to go to these international meetings. It's hard to be part of these international conversations, and if you don't have that sort of strong point of view, because as we can see in this panel, and we had a European regulator, we'd see that perspective as well. Like, regulators are balancing these things. They're trying to understand how they can get to a harmonized place, and they're looking for the best answers. So I think I hope that we'll see US policymakers take up that challenge, because I think it's really important, if they're going to put a uniquely American point of view out there and be part of these conversations, they have to do that through an American law.
Let me then sort of look at the flip side of interoperability, the whole issue of data localization. What is driving that? Is it law enforcement surveillance? Is it really a concern about consumer protection, or a trade issue? There's so many different ways of looking at it, and in order to resolve, I guess, the problem, we kind of need to understand the drivers. So I thought it'd be very interesting to hear how everybody sees localization evolving, or has. I mean, it looks like the Chinese law is going to be something to watch in that area, because it has a specific provision. Some people consider the GDPR to be a data localization law. People's definitions differ, but what's driving this, and how do we deal with it?
I mean, just very quickly, I think it varies by country, the reasons or the motives, but I think the most common trend behind it is interest in protecting consumer rights and national security. And I think every government is identifying certain categories of data that it deems too sensitive or subject to manipulation to be able to just flow freely across borders. And in every country there are exceptions. Some data has to be kept local in most circumstances, but I think that's part of the problem, is that the reasons do vary by country. So trying to find common ground sometimes is difficult, if especially if a country is increasing the scope of data that needs to be kept in country, and in the scope of scenarios under which consent is required to move that data internationally. So it's very challenging.
Any other thoughts on that?
If I may, it's from the, I think, Latin America point of view, at least from Mexico, it's quite different. What we have, obviously, we have two different regimes and two different laws, the private sector, the public sector. And we don't, for data protection, we don't make a difference on data localization. For us, it's just transparent. You have to comply with this if you are an entity that is treating data in Mexico. That's it. But the importance of the right protection of it, it comes with other things that may be addressing of national security. For an example, some data of the government is actually requested to be storage locally in Mexico. So some governments have some big data centers in Mexico, even if they are not the owners, they rent it locally in Mexico just for these purposes, because this national security sensitive data. But from the private point of view, we don't have any restrictions. So it's pretty much common that any company have any cloud disposition or cloud capabilities outside of Mexico. So for us, it's kind of interesting because many of the companies that provide these kind of services more frequently join us with the United States entities that actually treats United States data because of the how we are near of us. But it's interesting to know that we actually, you may be complying better with the Mexican data protection laws if we were, for example, addressed with the cloud protections over Europe, and maybe just say in many multilateral companies like Ireland. So for us, it's like really funny, because it's like, okay, you want to comply with Mexican laws, but you have the means to do it, but frequently you put us with the United States that has a more flexible auto-regulation laws that not necessarily comply with Mexican laws. So we find these asymmetries, and for us it's kind of interesting because obviously the private sector has the need, and not always we have the infrastructure locally. And we don't have a law that actually mandates, at least from the private point of view, to have data localization. So it's, as Sam was stated, it depends on country from country, but what we see is that we can achieve, we don't need data localization. What we need is to actually, everybody just to comply with Mexican law, even though you have your data storage in the United States or in Albania or in Brazil, just to make sense that the data that is being stored there, it's being complying with Mexican law, or at least with an international standard that complies with the minimums of Mexican law. And that would be it for us. So I think that should be the model that we should be trying to chase as countries, but obviously there are other countries that doesn't have the same understanding on human rights and civil liberties that would be actually asking to take control on this. And I think that it doesn't make sense if we have strong regulations and we keep the data with enough cybersecurity measures so that we actually know that the data is safe, even though it is not living on the country or is not storage in the country. It doesn't matter. As soon as you get a sense of what the protection is, and you have your cybersecurity and your security measures stated there, and there are great measures over international standards. I don't know, ISO 27000 for say so. You should be able to just storage the data to where it's better for you for any given reason, and not just be waiting that you have to comply and you have to have your data in here. It makes sense for maybe government data, but it doesn't make sense for private sector data.
Any other thoughts on the localization question?
Yeah, just to pick up on that. Oh, go ahead, Marie.
Yeah, just to echo Sam and Vitelio, I mean, my guess would be the implications would be different depending on the country, the outlines of the policy, and the reasons for doing so. But to the extent that it's to avoid situations in which companies move data to other countries with weaker privacy frameworks to avoid, what they see as excessive regulation, I think that strong, consistent regulations in multiple countries could help eliminate some of these incentives.
Chris?
Well, I would agree. I mean, I think consistent regulation is something that we're very supportive of because, frankly, we think that the lack of it can cause distrust and cause concern. And we see that certainly in the Schrems II decision, which of course was not hinged on national security and redress for national security issues, not commercial privacy law. But I think commercial privacy law was still an important unspoken component of that decision. So certainly we have to, as a multinational company, you have to meet individual countries where they are and understand what their concerns are. I would say that we also have to, just to build on the theme that I've heard from everybody else here, we really do have to parse the individual desires that are underscoring localization. So for some, it's making sure that data stays in country so their local law enforcement can get access to it. And that's very important and legitimate. For some, it's making sure that data is there so we can, countries can innovate and their local data economies can grow. Also very legitimate, but could be potentially dealt with differently. For example, de-identified data sets could be more widely accessible and spread out more broadly. And then, I mean, the wonderful thing about data, right, is that you can have 1 million copies of it. And certainly there are privacy issues that happen with that. And so we have to be very cognizant, but that those de-identified data sets could actually help with a lot of innovation and growth. And then we also have concerns about, a US, having a US provider and, for example, access to data by the US government. And those are legitimate concerns that have to be addressed through transparency, through clarity about when the laws can and can't access data, and and in some cases, potentially additional protections. So I think it's when we parse out these different, desires, we can see that there are going to be different regulatory approaches, different attitudes that can meet them and hopefully allow us ultimately to really derive benefit from data. Because that's, I think, the thing that we need to not lose sight of, is that so much of consumer benefit in the 21st century is being driven by access to data and innovative new uses of data. So we have to take all of these concerns very seriously. We have to understand they come from a place of both different cultural ideas, but also good faith and, a real desire to protect citizens. And then, so we have to meet them, we have to address them, and we have to create a space where data can be used innovatively.
Well, thank you very much. We are at time. I wanted to ask you all about your crystal ball for the future, but we just haven't had the time. But let me ask real quick, yes or no, will we be having this same discussion without resolution in 5 years' time? Chris, yes or no?
No, I don't think so. It'll be a different, I mean, we may not have every law that we want, but the laws continue to evolve around the globe, and we're going to see different discussions.
I'm happy to hear that. Maureen, what do you think?
I agree with Chris.
Vitelio?
Yes, also agree with Chris. I think that we are going to be at least 4 or 5 steps up on the level of protection, at least internationally.
Sam?
Yes, I agree with everyone else. I think in 5 years' time, there will probably be more interoperability and more alignment than more fragmentation, at least.
Well, that's a cause for hope. Thank you all for an excellent discussion. This session has been really tremendous. Thank you to the IIC for organizing it.
Thank you ever so much, Anne, and thank you to all of our panelists. An excellent final session. Thank you all.